Hello and welcome back to the afternoon session of Defense Diaries. I am your host, Bob Mata, and I am now joined by, she's trying to add herself. I don't see her. Oh, there she is, my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
I said the beginning part and then I waited. Are you on Ethernet or are you on Wi-Fi?
I'm on Ethernet.
Okay.
My Wi-Fi is off.
Maybe wipe your camera off a little bit. You look a little schmoopy. Oh, they're crisp and beautiful. Lovely.
Is that for real? Made a difference?
Yeah, of course it's for real. What? So we're back for the afternoon session. I don't know how many motions are left. I don't think a ton. I think there's a few left. I think there's one quasi.
I thought there was one where we were going to get to. Is everything about the video done? About the missing video and
what, the Sally port?
Yeah, because didn't they file? Oh no, yeah, we heard that argument where Brennan said
it's hard to know. It's hard to know. It's hard to know.
So we're never going. There's not one where we're hoping she's going to yell at the state for being.
Well, if she's going to give her answer to the
right, well, that, yeah,
and simply in writing and in terms of the motion to dismiss, then it will have to be, it should be, yeah, Sue, that appears very much to be the case. Sue had asked if did I verify that you weren't lying? I never thought you were lying, that's for certain.
I corrected it to be, was it factual?
Yeah, it's not a matter of me.
No, I use the word lying.
I
said, is that the truth? And then I was like, I mean, is it factual?
Very much that he has added them, which is impermissible.
Right. And I would have never thought you were lying. I just might have thought, could you have gotten bad
intel?
Bad intel, right. So, I mean, what is his good faith basis for doing that?
We have no idea. He just added him to the list.
I mean, he can't.
I know.
Are they going to discuss that? Are they going to bring that up?
They're going to have
that'll be a good opportunity for the judge to bark at him.
Yeah, they'll probably find out over lunch because I think it happened today.
So, did you see what Tracy sent you, or is that where you verified it? Tracy sent
it was verified on Twitter.
Well, Tracy sent you documents.
Oh, of course she did. I was pretty busy during our very brief little.
Yeah, and I forgot. I was on the phone with a client, and then I heard that Bob's pointing me to get out, and I heard the music. I was like, "You're going live again?" And then I was like, "Oh wait, yeah."
Tracy did in fact send me the updated witness list, and yeah, he added it. He says, I think it's got a footnote. It looks like counsel for defendant.
Well, somebody gifted some stuff.
Jackson, Little, and Yannetti. Yeah, he doesn't want any part of trying to cross-examine.
There's a footnote to authenticate media tour.
Yeah, I don't know.
Oh, wait. So check the footnote. Is that what she's saying? That means has something to do with.
I'm not seeing where I see the footnote 3, but I don't see that page. I don't see where the footnote is. It's not at the bottom of the page. So I don't know.
Let's see. Oh. Let's see which.
Oh, that's not the original doc trace? Yeah, I don't
No,
know.
she said she had to get.
There's a footnote to authenticate the media tour. So that's what they're seeking to call them for.
Right. I guess that's not an issue then. To authenticate the. Wait. Oh, wait. The media tour. Oh, yeah. Well, that is an issue.
Yeah, that's an issue.
Yeah, I thought you meant. I don't know why I was thinking like the show up. That I don't. I'm having a really bad perimenopause brain day. I mean, it's crazy.
I think you're fabulous. Just fabulous.
Oh, babe.
Let's see. Okay.
To authenticate the media tour. I mean, I guess that there'll have to be some stipulation.
Dang it.
I don't know why they let their client go out talking like that.
I'll never know. I don't know. It's strange. Like, it's not helpful.
Right. I mean, we're always telling clients, like, every word you speak, they'll change what you meant, switch the,
Yes.
and then, what, she's got to get on the stand to explain it. I mean, maybe she's going to take the stand this time.
I don't think so. I mean, she might have to.
What comes in? What comes in if she takes the stand? Well, I guess it could be a number of things. I wouldn't want her taking the stand either. It's not necessary, except to deny having done it. But
yeah, it's hard to say. All right, I've got it up, y'all. So I'm keeping an eye on it. Let me get it live. Up.
Is it actually playing? Is the arrow clicked? I can't see because
I don't have it up yet. I've got it here. It's not live yet.
How are we fixing this big, giant, long crime thing?
No, it won't look like that when it gets on there. Do you see it? Is it up?
What? Yeah, we see it.
Oh, did I share that?
I'm assuming so. Yes, you did.
Okay.
But you're not playing.
No, it's oh yeah, you're right.
Fair or something like that.
Okay.
My only point in making this is
oh. Okay. Let me get it. I'm gonna bloop it.
Just hit. Oh, it is playing because it sounded like the sound was on again before the.
It was.
And I think we can do it.
All right, so go back one.
I know, hon.
Sorry.
And I think we can do it.
Are you woman-splaining me?
Yes, I am.
Okay.
And I think we can do it.
Right.
We need to spend some time talking about voir dire, so I don't want to run out of time for that. So what I plan on doing is finishing these motions by 3 o'clock. We'll give each side 2 minutes. We'll see how we do with that. And
2 minutes.
We'll try and get through this. Juror questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you worked out a juror questionnaire?
I know you asked us to. We haven't.
All right, so today's the final trial conference where I'm supposed to have all of this, right?
What did they do the last 2
Can you
days?
do it before you finish?
wrong
Well,
with it?
let's see where we get with the motions and we'll see about that.
And Your Honor, if I could I finish that last point that I was about to make just before we broke?
30 seconds, Mr.
It's
Jackson.
only taking 30 seconds. I want the court to be super.
All right, now we
clear
get the
about this
picture.
What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. On the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day, is when
It's a law and crime issue, not us. They'll get it up. I saw it. I had to rewind a bit because it started timely, but law and crime's slow on the video.
the conversation, according to Jen, took place about Ashley, and could it have been some sort of an interaction or an affair or something like that.
Okay,
My only
There
point in
we
making this,
go.
and I just want the record to be super clear, is
I understand what your point is in making
there
it.
was no animus, no evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure.
all
that's
right.
clear.
Yeah, you did.
All right, well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannetti.
So you have 2 minutes, Mr. Yannetti. That's sort of a yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question.
Are we going to be pursuing?
Yes.
All right, so I'll hear you on your motion, Mr. Brennan, and then a 2-minute response. Jimmy, keep track, please.
Why don't you ask them
Thank
what
you.
you want to know?
During the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit the defense needed to provide sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court. The very first words of the opening were directed to third-party culprit. And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from the defendant's statements
Time's almost up.
that there was a position taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That position changed in the Ted Daniels interview when they were asked about third-party culprit, Mr.
We
Jackson,
don't care what happened outside
and
of
the
the courtroom.
defendant said they did not know. And so despite the recent position that they did not know who the third-party culprit was, in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there is this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of the Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See?
I've read your motion, I've read your memo,
Okay.
or the pleadings.
Thank you.
All right, Mr. Yannetti?
It's 2-minute timelines, rough.
Jim,
bro.
why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll
That's
hold
fine.
it to the end.
That's fine.
All right, Mr. Alessi, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium.
Yes.
Thank you.
He's boning up right now. He's getting all his pages lined up.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration, what it's going to be. They're looking, to me, this is a blank check. Similarly, with regard to Jessica Hyde, will use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate Software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property. And the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right. I appreciate your brevity too. Thank you.
You're welcome.
Mr. Brennan?
Wasn't easy. Does he get 2 minutes in rebuttal?
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored and how those windows are opened. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along and see them.
Okay. Thank you very much. I'll get a decision quickly to you in that. Does the defense intend to bring up any?
Yeah, see, the problem with her giving 2 minutes, which to me is absolutely absurd when somebody's life and liberty are hanging in the balance. What this is going to end up doing is whichever side she rules against, there's going to be a motion to reconsider and it's just going to get argued anyway. So,
Well, but I think I'm not 100% sure because I don't have it in front of me, but I think they're reading right from their written pleading. So, you know, a lot of times when I show up at court, I've got new law that I'm citing or I've got a case, you know, so I'll focus on what I didn't write, you know, because sometimes you can't put everything in your, you know, you want to make a somewhat different argument and say I rely on my written submissions. But what would be helpful, she's having them stick to a timeline, is to say, look, I read this. This is what I'd like you to focus on.
right. Ask pointed questions.
Right.
Appellate court style. Like, you know, we saw with the judge that was sitting on this very bench this morning before her. He was asking pointed questions. Same with Doolin, like he did in Carney's hearing for the motion to dismiss. It was very appellate-like in terms of the judge. Like, I've got zero problem with judges interrupting attorneys in order to ask good questions because it gets right to the heart of the matter. And at the end of the day, all that matters is that person sitting on the bench in terms of what decisions they're going to make. So in terms of answering their questions, there can't be a more important thing than to understand what they have questions about and trying to address it. When you're just guessing and you're up there just puking all kinds of shit out, it's not as helpful. So it does actually help, even though, as I see it in the chat, I'm like, why are they interrupting? Sometimes you want a judge to interrupt because then you have a clear understanding of what they are focusing on.
Right.
Any bad character or misconduct of John O'Keefe or any witness?
No. bad character evidence is inadmissible.
right?
To the extent that evidence could be used for like motive, opportunity, all the alternative, under proposed rule 404, we reserve the right, but we would approach sidebar before introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention of offering what would otherwise be prior bad act evidence, but they think it meets an exception under the rule, then they should propose that evidence. We have
They
time
can
to
use
consider it.
anything to show
Especially
bias.
if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right. So, okay. So what I'll do is not
Who is he
during
looking
the
to,
opening and
Bob?
only with advance notice and a ruling.
What would the advance notice be, Your Honor?
A week before, a week before the evidence starts.
Thank you.
Okay, that's paper 587, Mr. Clerk.
Thank you.
See, sometimes I think the defense gives in too quick. Like that. I don't
Commonwealth's
understand that.
motion for an offer of proof regarding calling District Attorney Morrissey and victim witness advocate Steve Nelson. And it also includes a request to exempt from sequestration.
Your Honor, with regard to this motion, we have on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yep.
The issues do go strictly to trial strategy and attorney work product. So any such offer of proof, we would ask, we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly, we could make those offers of proof at the appropriate time.
Okay.
Thank you.
All right.
Sir,
I'm
Bob?
satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Thank you.
All right, so they're both exempt from
See,
sequestration.
she was only going to exempt one. Just let her exempt the one.
Okay. So the other motions do seem like they may take a little bit more time. I'm going to actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it back on March 10th, right? With Michael
is.
Proctor being fired. Do you need some time to reconfigure this, or you want to just be heard? And for this, I'll give you both 3 or 4 minutes.
I think it'd be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of an advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right, so you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to provide them?
They have a copy of everything that we got.
Oh, okay.
We had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their position is? Maybe they found him acting unbecoming of an officer. I don't know. But those type of conclusions are what I'll probably object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I would need, I think, till the end of next week.
Is that a same timetable you would have whoever's arguing it for the defense?
That's fine, Your Honor. I would just ask for notice about what specifically the Commonwealth is seeking to exclude. There were some,
Right.
even just in the motion that they filed, there's
Yeah,
inconsistencies.
but I think it's all different now, right?
Exactly, but there's
So-
just inconsistencies between the title and then what's actually in the body of the motion. So as long as I have clarity, then I know what to address.
Okay. All right, is this something we should come in the day before impanelment and deal with?
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay?
Does the court intend to have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
That's fine, Your Honor.
Can you
I'll move
have,
as quickly as I can. I have a lot of
Okay.
obligations over the next week. I'll try to facilitate it. I just don't know.
all right, without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that, right? So,
Correct.
um, all right, so Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed, and when you, or that you feel should be excluded. And when you provide that to the Commonwealth, I'd like you to let me know as well.
I will.
All right, and then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it, and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor. I appreciate that.
All right, so on the 1st, you'll tell me how much time you need. All right, so Mr. Brennan, since we are making good time, I'll let you go back and finish what you were saying when I gave you a 2-minute, when I cut you off after 2 minute on third-party culprit. And then Ms. Giannetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Giannetti.
Your Honor,
Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're,
last time I said I wasn't excluding it, you just couldn't open on it. Right? So that's where I'm at this point, and I'll hear the different sides. So,
if that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but, you know, I guess I'll hear you on your motion on that then.
The requirements of providing evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice or confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would
You just described your entire fucking case, bro.
want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose as a target and the crime itself. Looking at the transcripts, I do not see that they've met a substantial basis between any particular individual and John O'Keefe. If we start from the premise that every single witness who testified that John O'Keefe never entered the home at 34 Fairview. Every witness, there is no substantive evidence that John O'Keefe ever entered that home. So to open up an invitation for the defense to
There's no substantive evidence that he didn't, other than a bunch of self-serving people saying he didn't. You're muted. Hold on. God damn it. Wait. Hold on.
Bob, you're muted.
Thank you, Mandy.
But it's just like you said. I mean, they're that's like their entire case. It's like saying no one saw Karen Reed hit John O'Keefe with the car, despite everybody being right there, including the car I thought that was there until she pulled away. The people behind her. I can't remember now, but
All I know, he just described his case perfectly.
they didn't see him get out of the car. They didn't
They
see
didn't
him
see
standing
shit.
there.
They have no substantive evidence with regard to their case at all. It's complete speculation. Same shit.
Start to present evidence, sometimes alleged prior bad act evidence or character evidence is unfair because then it becomes a mini trial for each witness. And so I haven't heard any basis or any proffer by the defense
Schmuck?
that would substantiate any particular witness is a third-party culprit.
Does this guy still
Colin
not get it? This
Albert
defense attorney,
Higgins.
this absolute defense attorney, and who has been for a majority of his career,
Right, I mean,
not
that's who it
understand
is,
that
right?
fairness only relates to Karen Reed. I mean, they want an equitable trial, but in terms of fairness, the fairness goes to the defendant. And her
They're
ability to be able to exercise her Sixth Amendment right to cross-examine the shit out of people outweighs anything that he's talking about.
Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They
Yeah,
have
there is.
used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third-party culprit? What evidence do they have that they want to introduce? There has to be parameters and limitations if they're going to try to introduce third-party culprit evidence, not only about who the person is, but what evidence are they going to introduce? Otherwise, we're going to spend half the trial at SAR by fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense to identify who the third-party culprit is and what do they want to introduce. Do they have a witness?
Did you read the
Do
transcript?
they
of the
have
first trial?
evidence? Do they have any records? Simply assailing people's character randomly is improper, it's unfair, and then it causes the Commonwealth to have to spend extraordinary time.
Hank just needs to shut up and sit down. Like, this
I
shit's
hope Yannetti
ridiculous.
says, unless Your Honor has some
Everything that's
questions.
at issue, the Google search at 227, the fact that he was invited to that house and was supposed to be going in, those are all absolute
Evidence.
nexuses with the fact that everybody in that house, in the eyes of the defense, is a suspect. How about that,
Guy
Hank?
just says bullshit.
I was trying to get to that
guy
one.
just said is bullshit.
I was hoping I was
Budding.
going to beat Mandy to it, but
No.
she got it.
Yeah.
Which is going to confuse this jury, and it's prejudicial. So I think that the court should order the defense to articulate who they claim their third-party culprit is and exactly what evidence they're going to introduce to support that claim.
I think the
It's
court
not
should
until they
order you to
articulate it, we
actually
can
read
really
the
fashion
transcript from the
an
first
argument
trial.
for the court, whether we think it is appropriate or whether we think it's insufficient. But now it's just an empty box where, as in the last trial, the defense can simply get up and blame anybody and everybody. And that's not the way the court and the courts have seen third-party culprit evidence. There's a standard, there's an obligation. It hasn't been met. So at this point, the court should preclude third-party culprit evidence. They shouldn't have, they could certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding, there would be no guardrails, there'd be no parameters, and it would be chaos.
How kind.
All right,
Brennan's
so
allowing him a
Ms.
vote.
Giannetti, I will hear from you, and I'd ask you to focus on, could you tell me whether this is pure third-party culprit, third party as it goes to Bowden, or is it simply somebody else did it and we don't know who?
It's
All
the
three.
second alternative. In other words,
Okay, so that's a little bit different, Mr. Brennan, not pure third-party. I'll still, go ahead, you can go over there. It's a little bit different if it's third-party as it goes to Bowden, but we know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell us who, last time you told me You don't have to prove that, but
Why doesn't he-
can
Well,
you
it's
make an
still our
offer?
position
Oh.
that we don't have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
3, yes.
Okay, so can you tell me the 3 that you say it is?
Sure. So the potential
Colin.
third-party culprits that we have identified
Higgins,
are Brian
Albert.
Albert, Brian Higgins, and Colin Albert. I
And it
have,
is both 1 and 2. It's not
evidence
just
with regard
Bowden.
to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Well, I'm just sensitive to the fact that the court is seeking not to, pollute the
So
potential.
we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over here?
I mean, I don't know why he's giving in to just third party under Bowden and not third party, because he doesn't have to identify a person if it's third party culprit strictly. If it's third party culprit Bowden, he's got to, I don't know that the police were aware of. Oh no, I think they didn't somebody in the chat maybe tell me, because I'm not sure Bob will remember, but didn't
How dare
Yannetti?
you, madam?
I
I
don't
have
know,
an
but
impeccable
didn't
memory.
Yannetti either get well, you guys just watched I still haven't watched the thingamajig, so maybe it was in there, but didn't the documentary, didn't Yannetti either send a letter to the Commonwealth laying all out what
Oh yeah, I don't remember.
but
That was out there. I like no what was out there is that he had sent a letter to either the AG's office or the US Attorney's office, laying it all out there. Like I don't know if that's true or not. Maybe somebody in the chat does.
No, but he said that they subpoenaed earlier. He said the U.S. Attorney's Office subpoenaed his file, but I thought something about in the beginning that he shared all that with the Commonwealth, and I'm sure he did.
So
They're
somebody
saying-
had asked to explain Bowden. I think it was, I don't know who it was. It's basically talking about that, they have a right to bring up inadequate police investigation evidence at trial.
And as the judge pointed out, in that case, you have to show that the cops were aware of this potential suspect, and then they didn't act on information they had.
Like
So
when they
that's
didn't go in and search Brian Albert's home, just to make sure there was no tomfoolery that had taken place in there. Despite the fact that they had a dead guy on the front of their lawn. Objection. If we're lucky, Brennan's going to allow Lally to do up the ejections, so we can still have the Bob ejections in trial too.
Where'd she go?
Who?
She up there? What's happening?
Potty break, maybe?
Why are they showing us the jury box? Is that the jury box? I can't even tell what I'm looking at.
Hot pocket. We're going to take a comfort break right now. Good old Judge White and his comfort breaks were the best.
Somebody's got like a little computer over there. What are they showing
Computer.
us?
Those are boxes of gloves.
No, I mean on the very, very back, it looks like the courtroom is on the screen unless we're looking through something.
What? We're looking at the back of 2 chairs.
Oh, we're
witness
looking through the
stand,
handle.
in a
Okay.
box of like four boxes of
I
latex
see
or
that.
otherwise.
I was looking at there's must be another chair butted up against the back of the other
There's
thing that
2
was-
chairs right next to each other, and you're
I'm
seeing
talking
the
about the thing at
arm
the
here?
back. Yeah, that
What
arm.
the hell are you talking about? This thing here?
Which is the
Smart
arm of
little
another
mouth.
chair, right?
Yes, it's another
Yeah.
chair. It's chairs.
It was confusing me. I thought it looked like a screen.
All right, listen, man. Where's OnlyFan? I don't like the whole. There you go.
Thank
What
you.
the- what is
Gosh,
this Jack of the
people have come
Chair shit?
accustomed to certain things. What is this
Yes.
camera guy doing?
Switching it up from OnlyFan, like the producers, like, dude, OnlyFan, what are you doing?
Right.
What are you doing?
But I don't know what she's doing. Didn't everybody walk back to their tables? Why are we only fanning again?
Oh, wait, we've got some bloops. Bloop, bloop, bloop,
Oh,
bloop, bloop,
wow.
bloop, 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 bloop,
Good thing
bloop,
we
bloop,
didn't
bloop,
miss
bloop,
that chair
bloop, bloop,
shot.
bloop, 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 bloop. Wow, this is a lengthy little. Is this a sidebar? Okay. Now we're
No more questions for Allie today. Oh, Lord.
Hank in his little seat in the front of the class.
The defense has to make a decision as to what you intend to provide me so that I can make this ruling. So,
What?
all right, next is the Commonwealth's motion in limine to exclude the expert testimony of Garrett Wing. I know nothing about this person other
Dog
than
guy.
your motion just says that all you have is a CV. Does the defense intend to call this person?
Melanie Little's expert.
I'm going to address that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand
Like
up?
2 minutes. Just my first question is,
Who is he?
who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby. And he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
All the things.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and the Commonwealth shouldn't be in a compromised position of receiving late discovery and trying to deal with it. So I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can you do it by Monday?
Yes.
Yes.
Is that acceptable, Mr. Brennan?
Yes.
Yes, thank you.
All right,
Yes, I
thank
can.
you.
He's my favorite.
So
My
607,
favorite guy.
Jim, is the defendant will provide reciprocal discovery by Monday, the 24th.
Sleuthy, I did. I put the clip up. I told Brennan, go watch it. Here you go. Here's your answer, Brennan. This is what he's going to say from Melanie's live.
All right, the Commonwealth's motion eliminate to
We're sleeping
exclude
in that
defense
day. We're
expert
working.
Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figure this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes, might be lengthier than the others we've heard.
All right, I was yapping through which one. was.
She just said she thought it might be lengthier.
No, but what motion?
The defense would like to call
FBI
Mr.
expert.
Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses, and then the witness would have the opportunity to respond or explain or admit any type failures.
Is he saying that the defense can't put on a witness to talk about proper procedure in an investigation? Is
Yeah.
that what he's implying?
He is.
Okay, you know what? He could shove it right up his ass, bro. That's what he can do.
This is an attempt to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be. That would be totally improper opinion and inadmissible.
Why?
They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories.
Yeah, we get it, Ipsy Dixie. Like, if he's just going to Ipsy Dixit it all day, like, is he going to cite any law ever?
I mean, hopefully the
Get up
response.
here and say, is he going to cite any law ever? I mean, this guy literally just gets up there and says shit. We understand what you're saying. You're wrong. And if you're saying that we're wrong, provide some precedent for it, buddy. I mean, shit.
Without reasonable doubt and
One
suggest
case, they
why
excluded
somebody
such
else
an
committed
expert.
the crime. I've done quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there
That's the
are
question.
different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they can confront the witness. And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest, like information in data records or phone records. Rather, a summary witness of a witness who wants to come in and give their personal opinions about this case.
I've done quite a bit of research, but none of it was case law.
And I didn't tell you anything about it.
Right.
Like a case that
He's
says
now
that's not
closed the
allowed.
binder, so he's wrapping up.
I don't see any grounds for admissibility for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different, and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the
So
defendant?
the police are gonna get on
I
and
need you to
say why
start
they
by
did-
telling me what you expect him to testify to.
I can
Yeah, that
certainly
their
tell the court that we do
investigation
not
is
expect
ridiculous.
To seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent.
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should
How
look
is he
like.
an expert on that? How is that a field and how is he an expert on it?
I'll go
Is
through
it
that.
something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues concerning or taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure.
All right.
I've already shared it with the Commonwealth, but I'm
Yeah.
happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, et cetera.
So is the basis of his testimony just crime scene, like collection of
No.
evidence? Or is it
Interview of
Witness
witnesses.
when
interviews.
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both. Because if someone tells you as an investigator, someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like
Failure to interview witnesses.
cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature.
How you create a chain of
There is
custody?
certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side. They're nearly word for word. And the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the rules of evidence 702, the federal rules of evidence 702 clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the rule 702 allows for experts with specialized experience, specialized knowledge, specialized education beyond that of an average layperson, in particular, in a field without, or in a particular field without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formally coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all.
So I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report.
Okay, so that's what I need. That would be much more helpful to me.
Then I don't know what more the court would like.
So I wanted to know specifically what you intend to have him testify on. But if it's in his report,
It's in his,
then
it broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him, we've already asked him to review. He's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative.
So I guess that's
technique.
my question. So without seeing the report, where are there standards and best practices? Is that something that somebody can turn to and see codification of it, or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocol.
They're never going to find a protocol that says that you should keep blood evidence in red solo cups, Judge. They're never
But I
going
mean,
to find
she's
it.
saying, is there somewhere someone can look, like in one spot, to know what's,
Yeah, I mean, the one thing that you're never going to find, Judge, is that any agency that deals with law enforcement ever saying that you should keep blood evidence in red solo cups. So if you're looking for that, Judge, you're never going to get it.
Calls for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right, can you get me that report before you leave? Do you have it extra?
I think
All right.
I think we probably have an extra copy of it. Yes.
Mr. Brennan, did you want to respond?
I do.
Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel
why aren't they
so
citing
that they
cases
can
that allow
use
that?
some type of opinion to lean on when they're arguing to the jury they should have doubt because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions.
Yes.
If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that will never be able to have an opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing?
Yeah, you can put
I
them on
don't
in
think this is an
rebuttal.
appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowdoin defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowdoin type.
No one in the free world thinks that Hank Brennan just searched for case law regarding this type of testimony with respect to a Bowdoin defense. No one. No one thinks that you actually did that, Hank. No one does. Do you, Allie?
No.
Type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness
That would be
to talk
hilarious.
about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between
Good luck.
people's personal opinions. That's done outside of the court.
Is there a cop out there that's going to just absolutely fucking submarine his entire career and reputation by getting on the stand and saying that that was an outstanding investigation? I challenge you, Hank Brennan, to find that cop. Find him. Find him. Find him.
Courtroom, not in a courtroom. we will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
So pause it real quick.
Yeah.
I wish the defense would have put forth some case law, because I mean it does happen.
Did you do a little research?
Well, right now I just put up a case where the defendant on appeal was claiming ineffective assistance of counsel for failing to use an expert to establish his Bowden defense, and the court says, um, there's no question that the defendants have the right to base their defense on the failures of police adequately to investigate a murder in order to raise the issue of reasonable doubt to the defendant's guilt. It is also true that the expert's affidavit demonstrates that the police did not conduct every test that could have been conducted. However, the defendant failed to show through the affidavits that the forensic examination DeFrost describes were reasonably necessary or appropriate for the police to conduct in order to investigate the shooting properly, such that a failure to conduct them might create a reasonable doubt about the defendant's guilt. So, I mean, that right there, and it's the Supreme Judicial Court, by inference is like, well, if he had said that, then he could get in, but his affidavit didn't establish that, even though she did say the affidavit demonstrates that. So it sounds like you can call an expert, an independent investigator, to say that they didn't conduct, in order to properly investigate, they needed to do X, Y, and Z, and the failure to do it might have created reasonable doubt as to guilt. And that's just like the first case I pulled up, so I'm still reading some, but
I know there's a lot of law tube channels out there, but I don't know if you're getting that kind of research that quick anywhere else. So here's the one thing that I have. That was on Joke Mando. So the one thing, because one of the things that I've always been kind of, all right, it's on a loop, was whether or not they could ask him, in his opinion, whether or not there was enough probable cause as to getting a warrant to get into that house.
I think so, but I don't know.
I think so
I'd have
too,
to do
but
some more
I've
research.
gotten pushback on it. I've had debates on it. Like when Joey Jackalone was doing the tubes, and he's a cop, and I asked Joe and Mikey Alcazar were both on, and I'm like, yo, like, do you guys think that there was, in your minds, was there enough PC to go in and try to get a warrant to get into that house? And I think both of them are like, I don't know. I'm like, what? I'm like, there's a dead body on the front yard. The guy was supposed to be going into that house. Like, you don't think that's enough PC? So those two guys were kind of in the mindset, maybe. I think I kind of talked him into, well, you'd at least give it a shot, right?
Right.
So, but I'm curious as to if she would allow that to happen. You know what I mean? In terms of them asking him that question. Because ultimately, I mean, there was a cop sitting in there, like talking to them, but they weren't in any way, shape, or form processing and searching the home. You know what I mean? They were just sitting there eating donuts and drinking coffee. Where's my high hat on that one, Mandy?
I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
you wouldn't be objecting if they called somebody in rebuttal to reinforce?
No, I would
can't
stand on my table and applaud it, because it would be the greatest goddamn thing I ever saw. It would be hilarious. It would be hilarious, Your Honor.
They have they put on their
one of those clowns on to say that was a great investigation. I would pay, Judge.
Right.
A great investigation.
Oh no. Mr. Brennan said, what if I called a Massachusetts State Police officer to say that this was the best investigation ever?
That's their investigation.
I have two words. Do it. Do it. I'd love that. I'd love a shot
Okay,
at
so
that.
I said, let's take personal.
That's
out
not
of
an
this.
invective. That's not a personal shot.
Is there
Mr.
an
Brennan.
echo
I'm just
in
saying, do
here?
it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put my
No, but
Easter
his
up against
answer
any
should be
expert they want to call. But the reality is, Your Honor,
they don't
we
get
are entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within.
I don't know. So if you can give me a case site for that, all right? That expert testimony regarding a Bowden defense, I've never seen it. I've never seen it in research or anything. So I'd like a case site.
There are certainly cases outside the jurisdiction.
Yep, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts. There, to my finding, to our finding, there isn't one directly on point, but there are plenty, there's a myriad cases outside the jurisdiction where.
Be the hero, Allie. Find the case.
Well, I mean, it's
No, find the mass case. If anybody can do it, Allie can. Allie,
sure
Allie.
they all look. No, I put in here
Your
proper,
hi-hat is
accepted,
off,
acceptable,
Mandy.
adequate, inadequate in this with intent of police investigation or Bowden in the same sentence as expert within 250 of fail, investigate, interview, witness. I don't know. I'll think about it, but I'm sure that they did thorough investigation. I'm looking at
They
38
being
cases.
Eliza Little
Right.
and
But I
Pavlis.
think that case that we just cited at least shows that they are allowed to call an expert and it lays out what the expert would need to establish.
Exactly.
So I feel like
Sometimes the silence of there not being any precedent just means it's so straightforward that you can absolutely do that. Like the concept that you can't put on one, it's like the concept of, if you've got a malpractice suit against a doctor and you know how hard it is to find one doctor to testify against
somebody
another
send me
doctor that
Little's
doctor screwed up. It's the same concept here.
somebody send me Little's email address. I'll send her this.
All right. Or just I could tag Unetti on Twitter. We follow each other.
Yeah, but if
he's
paying attention,
investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field, one that's utilized throughout the
So
country
I
all
need
the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I think that's it for the motions in limine. Did I miss anything?
Hank's got to get his binder in order.
Well, I need that. Oh,
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first. Is that your understanding, Mr. Brennan?
Yes, and we have none.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
I regret we don't. We have not spoken.
Your Honor, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate questions. Right. If in addition to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial, and so close to jury impanelment, it makes sense to me.
Oh, I'm sorry, Your Honor, I was looking at for outside cases. No, there's no objection.
All right. So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties. All right. File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So if I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Obviously, it would be a day after Monday then, right?
Yes, Mr. Kennedy, it would be after Monday.
We did file 2 motions today that at some point we'll need a hearing on.
Okay.
The defense just received notice this morning, so they're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
Oh, do they kill it? Wait, they're going to give the date. Long Crime's getting a little happy with their trigger finger there. See, I can almost make the exact same noise in real life. All right. Well, we don't get the date. Long Crime got a little itchy there, so we'll have to figure out when that date is. I'm sure Tracy will get that to me stat as soon as that's out for public consumption. So interesting day in court. I had a blast today. I had so much fun today. Allie is deep. So in case y'all are wondering what my wife looks like when she's researching, you're looking at it firsthand. Like the only thing that's missing is me floating in the background, like saying things to her and her not hearing a word that I'm saying. Like, so it's instead it's just me on this side instead of like actually in the room with her. Say, hey babe, like, and then I'll say, are you listening to me? And she'll be like, she'll repeat the last 4 words as if, you know what I mean? She's the best. All right, you guys, let's see. Tuesday 25th. Oh, Allie's gonna have to go solo. I'm gonna be in Bloomington for the Jamie Snow and I'm going down for 2 appellate arguments that they're holding at Illinois State University for Jamie Snow. In the case that I am desperately trying to get Lauren Bright-Pachenko to cover with me next. But I'm not going to tell you because I don't want you guys to look into it because I'm going to do a live on it. I'm actually trying to do a live before the 25th. I'm not holding my breath because there's a lot. It's an insane case. This guy's been in for a really, really long time. And it's the same county that Jamie Snow shit went down. Same law enforcement agency. So got a lot of the same things going on, but it's an unbelievable case. I cannot believe that this particular case has not gotten more traction. You guys will see what I'm talking about when we dig into it. All right, let me shoot out some quick thank yous. We've got thank you for my anonymous gifted. Oh, Chance Cooper. Aw. You got back on the horse. Somebody gifted you a membership. Welcome back to the fam. Aw, family hug. Kaylee, there's a footnote to Authenticate Media Tour. That was in relation to the addition to the defense team. Thank you for that, and thank you for your generosity. Wubby Farm. Wait, is there a good brain day in perimenopause?
Oh, that one got one.
That was a little better, Mandy. You're getting slightly better. Somebody can land a joke.
I wanted to tell you this.
Yes.
So this case that I'm reading, it says, God, open up already. It says, hold on. Okay. Wait. Okay. The expert testified that as a result, when experts get contextual information, even if it's irrelevant, it clouds a judgment and it contaminates the mental processes. Like his expert getting all that information. All right, never mind.
Yeah.
Forget it.
No, it was good. It was good. Can I keep going?
Yeah, I'm done.
All right. Jim, I respect Turtle Boy, but can't say I'm a fan, but it is Is it time for Turtle Boy to fall on the sword to help distance themselves from him? Much respect, Bob and Allie. I mean, like, I think you saw that. I think you saw that, like,
Not this
unequivocally.
morning.
No. That was different. You saw and heard it the other day when Alan Jackson made the argument. He was definitely distancing themselves, like all of them, from Turtle Boy, calling him the blogger. I think that they did that, or he attempted to do it.
To get
That
on
was the part that I was
judges.
worried about in light of what I saw pop up on that Max documentary. I'm like, oh, like Alan's in there making representations that the defense has never done anything, and like Hank, if he gets the opportunity to try to shove some shit right back in his face, he's going to do it. We saw that this morning in the hearing. He already brought up, he tried to play the clip, the exact clip that I'm talking about, that I was talking about 2 days ago when I was telling Allie to watch that episode and telling you all to watch it. I'm like, oh, I'm worried. So yeah, I hear you, Jim. I hear you. I mean, more importantly, if if Turtle Boy, I mean, like, you got to believe that he feels what he feels. You would think that at some point he's got to be like, yeah, I got to do what's in the best interest for her case. So, I mean, but he, like, I mean, it could be a difference of opinion. He could feel like that he still needs to create pressure. It's hard to say. It's hard to say. But thank you so much for your generosity. And then Leslie, $5 super sticker. Thank you so much for your generosity. Yeah, Jamie Snow, it's one. It's one that like definitely out there that needs to be remedied. It's time. It's time. So we'll see. So I'm looking forward to that. But Allie will have to be with you all on the 25th solo, because I will be indisposed on that day. So all right, you guys, please, on the way out, make sure you like, share, subscribe. And tonight, if y'all like are not on to the Richard Allen case and the Delphi case, and you're only on to the Karen Reed case, I am telling you, they are like mirror images of one another, except completely different fact scenarios. Like, you guys, so tonight we've got Stacey Eldridge, who was Richard Allen's forensic data expert. She was the examiner. She's going to be on. We're bringing Andrea Burkhart on with us, and it's going to be great. It's going to be one of the better lives out there. I would put it maybe ever. I mean, that might be a bold proclamation, but I'm really excited about it. I've been trying to get Stacey on for a hot minute, so I am very, very, very excited about tonight's live. So make sure you hit your notifications for that. Also, if you see that thing, go ahead and give it a like over there. We want to get it in the algo. I want a lot of people. I imagine we're going to have a pretty big audience tonight. So, but again, if you guys are strictly Reed and you haven't even given a side eye over to Alan, do it. Do it. I promise you. It's just as jacked up. It's just as jacked up. All right, you guys are the best in the business. We will see you in a few hours. Because without you guys, I'm just an old man.
Talking about a lot of cases.
There it was. You saw it live and in person.
Mm.